say that this is dicta, and then therefore the court doesn't have to follow it. It's persuasive, but it's simply dicta. That is absolutely incorrect, and we will prove that beyond any doubt, starting by looking at the definitions of holding, dicta, and precedent. The definition from Black's Law of holding is a court's determination of a matter of law pivotal to its decision. Dicta is the opposite. A court's discussion of points or questions not raised by the record or its suggestion of rules not applicable in the case of bar. Now, as to precedent, a case becomes precedent only for such a general rule as is necessary to the actual decision reached. What I'm going to show is that the definition for minor was pivotal to the decision of that court and is therefore holding of that court and therefore precedent, which is binding, means Supreme Court precedent binding on every court in this country. The definition was what the minor court had to decide was whether or not Ms. Minor was allowed or had a right to vote under the 14th Amendment. However, it specifically stated that before it got to that part of the question, it first had to determine whether or not she was a citizen. Well, using the well-known doctrine of judicial restraint, the Supreme Court will not reach or will not construe a constitutional clause if it does not have to answer the question presented. And in this case, Minor was born in the United States and had both parents were citizens at the time she was born. So therefore, what the court did was it defined a natural-born citizen, and it specifically said she's a natural-born citizen. Therefore, we don't have to determine whether or not she's a citizen under any other rule. It was pivotal that she was a natural-born citizen. The definition they came to was part of the holding and is binding precedent. Now, there's other language in this paragraph that others point to as saying, well, there was doubts about this particular definition, even if it's precedent, because the paragraph goes on to say some authorities go further and include as citizens children born within the jurisdiction without reference to the citizenship of their parents. However, the court should be recognized also that the term citizen is not natural-born citizen, and the term citizen was specifically defined by the minor court on the previous page. In fact, they spent at least a couple of paragraphs discussing what a citizen was and describing how it's a very broad term. And at the end of that, they concluded that when they say citizen, they mean nothing more than this broad, nebulous term that they don't need to define and can't define. And in fact, the rest of the paragraph goes on to reflect this judicial restraint that the minor court was using when they say, for the purposes of this case, it is not necessary to solve these questions about the doubt of what a citizen is. It's sufficient for everything we have to now consider that all children born of parents within the jurisdiction are themselves citizens. In other words, Minor is a natural-born citizen, therefore she's a citizen, and they moved on to the next question, which was construing not the whole 14th Amendment, but just what rights arise from the 14th Amendment, whether or not she could have the right to vote. And by the way, that court held that the 14th Amendment does not create any new privileges or immunities. Therefore, someone who's not qualified as a natural-born citizen to run for president before the 14th Amendment does not have that right, because the 14th Amendment didn't create any new rights. They don't have that right after the 14th Amendment. So, that's the holding of Minor. A lot of people say that Minor was overruled by Kim Wong-Ark. That's absolutely not true. The holding of Kim Wong-Ark is right up here, and it's very limited. There's lots of caveats, there's lots of conditions, but the point is that the minor court, the Kim Wong-Ark court was determining what the minor court had left behind. The minor court had said, we're not going to determine what a citizen is under the 14th Amendment, because we don't have to, because she's a natural-born citizen. The Kim Wong-Ark court had that case because they had Kim Wong-Ark, whose parents weren't citizens when he was born, though he was born here. Is he a citizen? They answered that question, and that's all they answered. Everything else that they answered, everything else that's in there, anything that could possibly be construed to change the holding of Minor, the definition of natural-born citizen under Minor, was dicta, and is therefore not binding, and certainly under the rules of construction cannot overrule an earlier holding dicta certainly can't overrule holding. So the point here is, these cases don't conflict. They might look like they conflict if you read them, but if you look at the holding of Kim Wong-Art and the holding of Minor, they don't conflict. And when they clearly don't conflict, they certainly don't overrule each other. If anyone was to argue that the Minor definition of natural-born citizen is unclear as to whether or not it's required to have one parent or both parents, I would like it stated for the record that the minor court's definition of natural-born citizen uses the term parents. Parent is the singular. If the court wanted to use parent, it could have used parent. If the court meant mother, it could have used mother. If it meant father, it could have used father. It used the term parents, and that has to be given, again, a rule of construction. It's plain meaning. Its plain meaning is both parents, so that argument doesn't fly. In closing, this case is about the Constitution. Holding public office is not about the individual. It's about service to the public. Anyone who's run for public office ought to know that. And that means that even if an individual has an unfortunate situation where they can't rise to the level that they want to, politics is not a typical career field where we want the person to rise as far as they can. Politics is about service to the public, and that should be kept in mind. And my final comment, let me make the point for the record. We've shown, I believe, that Barack Obama's father was not a citizen of the United States ever, certainly during the time period when Barack Obama was born. I don't think that's ever been disputed by the defendant himself, and that means that he is not constitutionally qualified to hold office. It's not a statement about his ability, it's a statement about his constitutional qualifications. Finally, the defendant was ordered to be here today. He's not here. His attorneys are even boycotting this hearing. And I want it stated on the record that shows not just a contempt for this court, but a contempt for the judicial branch and
I'm not interested in the commentary of that, counsel. Are you done with your argument?
Yes, Your Honor.
Thank you very much.
Thank you very much.
Counsel, would you please introduce yourself and your client?
All right, Mark Hatfield. I am counsel for plaintiffs Paul Swinson and Kevin Powell, who are with me, my co-counsel, and my brother, Tom Hatfield, is here with me as well. Wanted to raise two quick issues before I undertake the evidence. Your Honor, first of all, we remind the court we have a motion filed with the court for determination of placement of burden of proof in this case, and which is pending. The other thing, Your Honor, is on January the 19th, I submitted to opposing counsel Michael Jablonski and filed with this court a notice to produce, which was directed to the defendant, Barack Obama, in this case. I note that Mr. Obama is not here today, nor is his counsel here today, and I would note that the court has authority under OCGA 50-13-13B to take appropriate steps to punish any contempt of this court, which results from the failure to appear and failure to produce the records and documents that have been subpoenaed in this case, and we would commend that to the court. In that connection, I would like to, at this time, tender plaintiff's exhibit number 10, which is a copy of the White House schedule for today, January 26, 2012, which shows no public schedule for the president. Judge, I would tender that into the record.
Okay. You want to mark it as exhibit 10? 10 is in the record.
But I will
Counsel,
call.
you have 20 minutes.
Yes, sir. Call Mr. Carl.
I do.
Will you state your name, please, full name?
Carl Swenson, Carl Alfred Swenson, Jr.
Mr. Swenson, where do you live? What's your address?
60 in Morrow, Georgia.
What county is that in?
Clayton.
Mr. Swenson, are you a registered voter in the state of Georgia?
Yes, I am.
And were you a registered voter in the state of Georgia at the time that you submitted the challenge which initiated this case?
Yes, I was.
And are you qualified and able to vote for candidates for President of the United States as a voter in Georgia?
Yes, I am.
All right. If I may approach, Your Honor. Show you what's been pre-marked plaintiff's exhibit number 2. Ask you if you can identify that compilation set of documents.
Yes, these are, the first one is from the Secretary of State acknowledging that the challenge has been accepted by this court, as is the second page. And the third page is the applicable laws and regulations pertaining to this case. The fourth page is Secretary of State Kemp's acknowledgement that they are going to put this, let's see. This is from the Democratic National Chair that notifies the Secretary of State that Obama is going, candidate Obama is going to be on the ballot. And the next page, official challenge, is what I sent to Mr. Kemp, requesting this particular hearing and having him be on notice that I was challenging Obama's being on his ballot.
Okay. The last page that's in that record, is that a voter record that indicates that for you as a voter in the state of Georgia?
Yes, it does.
Okay. The challenge that appears within that that set of documents, was that the challenge that you filed initiating this case with the Secretary of State's office?
Yes, sir.
Did you file that challenge within the time limit allowed by law for filing a challenge after the qualifying period ended for presidential candidate?
Yes, I did.
Your Honor, with that, I would tender plaintiff's exhibit number 2 in the evidence.
Exhibit 2 is in the record.
Mr. Swenson, you may step down. Call Kevin Powell.
Yes, I do.
You state your full name for the record.
Kevin Richard Powell,
Mr. Powell, give us your address.
Duluth, Georgia, 30096,
What county do you live in?
Gwinnett County.
Gwinnett County. And are you a registered voter in the state of Georgia?
Yes, I am.
At the time that you initiated the challenge or filed the challenge that initiated this case, were you a registered voter in the state of Georgia?
Yes, I was.
And are you able, as a registered voter in the state of Georgia, to cast a ballot for President of the United States?
Yes, I am.
Now, I'm going to show you what's in pre-marked plaintiff's exhibit number 3, and ask you if you can identify that for me.
This is from Linda Ford to Chief Clerk, the candidate qualifications challenge for Barack Obama, and has the Georgia Code.
Mr. Powell, let me sort of cut the chase for you.
Yes, sir.
Is that composite exhibit a record of the challenge that you filed with the Secretary of State's office challenging Barack Obama's candidacy in this case, and the related documents that were generated by the Secretary of State's office?
Yes, sir, it is.
Okay. I would tender plaintiff's exhibit number, is that number 3?
Yes, it is.
Is plaintiff's exhibit number 3 in that?
Dr. Orly Tates, thank you and welcome to the
Thank
show
you.
again.
Thank you for inviting me.
It's wonderful.